Assalamualaikum warahmatullahi wabarakatuh to the chairman, to my fellow friends and to the viewers who are watching right now. Maza and Co. Chartered Accountants was established in 2001 in providing accounting and related service. There are two partners are involved in this firm, which are Muhammad Amir and Zainal Ali. It seems that they have to be disagreement and different thoughts from each other. Unfortunately also that they don't have any written agreement for this partnership. We are strongly agree that this partnership should have a written agreement for the future actions. As this agreement could manage future debt and avoid legal issues. If the partnership involves in a huge debt, partners are personally liable for the business obligation of the business partnership. It had told in section 11, every partner in the firm is liable jointly with other partners for all debts and obligations of the firm incurred while he is a partner, and after his death, his estate is also severally liable in a due course of administration for such debts and obligations. So far, as they remain unsatisfied but subject to the prior payment for his separate debts. So it had proved that section 11 that even the partner's death also should liable for this obligation partnership. When one of the partners commits a wrong, he or she is made liable for his wrongly actions generally. His or she generally does not incur any liability on others. However, liability of one person for the act done by another person may arise. In thought, a person is liable under vicarious liability if offences other than criminal and breach of contract. In the section 12 in the Partnership Act, told that whereby any wrongful act or omission of any partner acting in the ordinary course of the business of the firm or authority of its co-partners loss or injury is caused to any person or penalty is incurred, the firm is liable. So it happened that in the case of Hamlin versus Houston, a partner bribed the plaintiff clerk to breach of contract by divulging secrets to his employee's business. Both of the partners' firm were liable for his wrongful act. Thus, we are strongly agree that the partnership should have an agreement to support and manage future debt and avoid legal issues.
I strongly agree that partners in Maza and Co needs to prepare written agreement. The importance of having written partnership agreement is to deal with future changes. What if one of your partner dies or declare bankruptcy? And how does it affect the partnership or the firm itself? Based on Section 35 in Partnership Act 1961, the partnership will be dissolved immediately upon the death or bankruptcy of the partner. But the things would be different if the partners has prepared written agreement. As in written agreement, the partners can clearly state when the partnership will be dissolved. Some partnership agreements even protect the partners in the event of the death of one partner. Thus, it is essential for the partners to have the written partnership agreement to ensure the process is cleared when the events occur. Example of the case where the partnership didn't have written agreement is Hu Yok Wah versus Lee Chu Yam Holdings Berhad 1991. One of the partners, Mr. Lee, has died in 1988 and his widow wished to replace him instead. But the respondent denied it as the firm has dissolved. So the court decision was, as there was no evidence, either written or oral, or seen from the actions of the partners, indicating that there was an agreement that the firm can still operate even if any of its partners die. Therefore, the firm was dissolved. With that, I agree that the partners in Maza and Co. needs to prepare written agreement upon the establishment of the firm.
Based on my opinion, I strongly agree to have a written partnership agreement in Maza and Co. because the partners can reach an agreement on the profit and loss distribution. Usually, when starting a partnership, each partner might want to form a written partnership agreement to starting roles and responsibilities of each partners and determine the loss and profit distribution. For example, the partners want to make sure the responsibilities and profit split into the partnership agreement properly, which is reflected the reality of the business. The lack of written agreement means that the Partnership Act will come into play. Section 26A of Partnership Act 1961, subject to any agreement expressed or implied between the partners, all the partners are entitled to share equally in the capital and profit of the business, and must contribute equally towards the losses of the capital or otherwise sustained by the firm. According to Maza and Co. informal agreed open arrangement, all the revenue earned will be aggregated as the firm's revenue and divided equally between partners, and also the firm had an equal share of equity in the partnership. Another agreement of Maza and Co. is that both partners will receive equal fixed salaries and bonuses monthly. According to Zainal Ali, each partner will serve their clients with ratio 40-60 for Muhammad Ali and Zainal, for Muhammad Amir and Zainal Ali respectively. Without a written agreement, the partners might face a conflict and misunderstanding in the future about the roles distribution, since Zainal Ali uh, have more clients to serve than Muhammad Amir, but divided equally on the revenue. This will cause a great of dissatisfaction for Zainal Ali, because even if an uneven workload occurs, the revenue is divided based on the informal agreed Maza and Co. The most problem for informal agreement is the partners are not clearly set out and recorded the agreement, which is the roles and responsibilities of the partners and the division of profit and loss, which may cause a misunderstanding in the future, since the partners interpret and remember the agreement differently. With the existence of the agreement about the roles of each partners, the partner will be bound as the agreement has been agreed by them. Therefore, I strongly agree to have a written partnership agreement for Maza and Co., where all the partners can reach an agreement about the roles and responsibilities and the profit and loss distribution to avoid a conflict in the future.
In our opinion, written agreement between partnership regarding partnership property are important as it can determine whether the assets belong to the firm or partners. Based on Section 23 in Partnership Act 1961, unless the contractory intention appears, property bought with money belonging to the firm is deemed to have been bought on account of the firm. If no agreement is established between the partners, then the partners must have the intention to treat the property as a partnership property. An example from case Muta vs. Castello in 1881, a property purchased using a firm's asset, although no use in the course of the partnership business, it's still considered as a partnership property. This means if the property is purchased with the private money of any partner, property is considered the private property of the partner. Also, if there is no agreement between partnership, there will be a problem when the partnership wants to conversion into personal estate of land held as a partnership property. Unless there is an agreement to the contrary, property of partnership has to be sold on dissolution. Therefore, related to the circumstances of Maza and Co., they did not provide any agreement to determine whether the building and the car was purchased as a partnership of private property. Generally speaking, this agreement leaves little room for misunderstanding or interpretation of issues such as dispute over the right to sale or rent property, provision of rental income or loss. So written agreement between partnership is important.
Based on the points that my groupmate and I have discussed before, it is important to have a written partnership agreement. The agreement clearly set out the details of what was agreed, such as time frame, materials, payment, and also procedure to follow in the event of the discussion. It gives the partner more assurance and minimize the risk in the future. To conclude, written agreement must be done between the partners to protect the firm and also the partners. Thank you.